Has the moment finally arrived for the Supreme Court to rein in these so-called progressive states that have been brushing off the Constitution like it's optional? Are we standing on the edge of a legal battle that could forever redefine how the Second Amendment is understood and enforced? In this video, we'll break down how a powerful statement from Supreme Court Justice Clarence Thomas might trigger a seismic shift in how our nation protects the individual right to bear arms, and how the state of Hawaii could be at the very center of it all. Before we dive into the details, let me lay it out straight. It is not the government's job to determine whether we're worthy of exercising the freedoms protected by the Constitution. Our founding fathers made it crystal clear that rights like keeping and bearing arms are not government-issued, they are inherent, God-given liberties. But here we are, watching yet another state turn a core constitutional protection into a privileged one that's only granted sparingly, if at all, and only after citizens jump through layers of bureaucratic hoops. If you've ever wondered what happens when a state tries to smother the Bill of Rights under the weight of political talking points, you'll want to stick around. We're taking a hard look at Wilson versus Hawaii, a case where the so-called spirit of aloha was used as a shield to justify gutting the Second Amendment. And by the end of this video, you'll understand exactly why Justice Thomas called out Hawaii's policies and how this decision could ripple across the country. Your rights, your voice, and your vote have never been more important. Here's something to consider. Could Hawaii's restrictive system become the new model for anti-gun lawmakers nationwide? Stick around because the answer may surprise you. Let's rewind to the year 2017. That's when Christopher Wilson went on what should have been an ordinary hike, but ended up walking straight into a legal nightmare. While exploring near privately owned land, Wilson was carrying a loaded firearm. But, and this is key, he didn't have one of Hawaii's concealed carry licenses, which are almost impossible to get. Law enforcement didn't waste a second. They charged him with criminal trespass and, far more seriously, with a firearms violation for carrying without a permit. Now here's where it gets interesting. At the time, Hawaii operated under a may-issue permit system. That meant the police chief, not a judge, not a jury, had nearly unlimited discretion to decide who got a license and who didn't. Unless you could prove you were under extraordinary personal threat, your application was dead on arrival. Imagine telling a woman being harassed by a violent ex that she has to prove her life is uniquely at risk before she's allowed to defend herself legally. Then imagine that same person discovering that Hawaii's counties had approved only 6 concealed carry permits for the entire civilian population between the years 1996 and 2017. That's right, 6 permits. In over 20 years, out of more than 1 million people living in the state. That's not a permitting system, that's a near total denial of a constitutional right. So when Wilson got slapped with charges, he pushed back hard. He argued that Hawaii's system wasn't just harsh, it was flat out unconstitutional. And the trial court initially agreed, tossing the firearm charge. But then Hawaii's Supreme Court stepped in and reversed the ruling. They claimed that the so-called spirit of aloha somehow trumped the Second Amendment. And that's when things really started heating up. The case grabbed the attention of constitutional scholars, gun rights organizations, and eventually Supreme Court Justice Clarence Thomas himself. His comments made it clear. There's serious concern that what happened in Hawaii could happen elsewhere, and that it's time for the highest court in the land to weigh in once and for all. Let's circle back to Hawaii's highest court using the so-called spirit of aloha as justification to clamp down on Christopher Wilson's right to carry a firearm. You have to ask yourself, have we really reached the point where a state can wave around a cultural motto and steamroll the Bill of Rights? Sure, culture and tradition matter. They shape the character of local communities. But when that culture is used as a tool to justify stripping away a basic constitutional protection, that's crossing a line. It's no different than a state claiming they value civility so much that they'll silence your freedom of speech if it's deemed impolite. You don't need a law degree to see the constitutional problem with that. According to Hawaii's Supreme Court, simply carrying a handgun without first navigating their tangled maze of red tape went against the peaceful nature of Hawaiian values. That reasoning might sound poetic, but it falls apart under any honest examination. The Constitution doesn't take a day off because a state decides it doesn't fit their cultural branding. Our nation was built on the idea that the Bill of Rights is the foundation, non-negotiable and equal across all 50 states. You can't simply sideline that because it's inconvenient for local politics. So what did Justice Clarence Thomas do in response? He did what he always does. He cut through the nonsense and got straight to the heart of the issue. He made it clear Hawaii was treating the Second Amendment like some second-rate right, subject to the whims of bureaucrats. If you've ever read his opinions, you know this Justice Thomas doesn't believe in selective respect for the Constitution. You either uphold all of it or you uphold none of it. From where he stands and where I stand, it's absurd to require someone to demonstrate they're in immediate danger just to exercise a right that's supposed to be guaranteed from birth. This collision between Hawaii's cultural narrative and the text of the Constitution isn't just a legal disagreement, it's a reflection of a deeper problem. In certain parts of the country, the progressive mindset has grown comfortable twisting culture and politics into excuses to bypass foundational law. And that's exactly the sort of tension the Supreme Court is meant to resolve. Now, you might be wondering if Hawaii's permitting scheme was so clearly unconstitutional, why didn't the Supreme Court jump in right away? The answer boils down to procedure. The Wilson case reached the High Court through what's known as an interlocutory appeal, meaning the case wasn't finished at the state level. The Supreme Court usually waits for a full record and final judgment before weighing in. But that didn't stop Clarence Thomas from speaking up. In his statement, he took direct aim at the Hawaii Supreme Court for brushing aside the New York State Rifle and Pistol Association versus Bruin decision from 2022. That landmark ruling made it crystal clear. You don't need to demonstrate special need to exercise a constitutional right. The Bruin decision shot down New York's proper cause rule, and by extension made Hawaii's exceptional case language highly suspect. Still, Hawaii's justices claimed Wilson didn't have standing because he never applied for a permit. That logic didn't sit well with Justice Thomas, who said it's ridiculous to make someone walk through a broken system just to challenge its constitutionality. That's like saying you can't complain about an illegal search unless you first invite the police into your house. While the High Court declined to step in immediately, the door is still wide open for Wilson's case to return once the lower courts finish their work. And if that happens, we could see a definitive ruling that forces states to stop treating the Second Amendment like a suggestion rather than a right. And let's not forget Bruin already forced a dramatic change in states like Hawaii. Where permits were once practically non-existent, they're now being issued in far higher numbers. That proves just how much impact one clear Supreme Court decision can have. It reminds us that the judiciary, when it leans on the actual text of the Constitution, can still serve as a powerful check on overreaching state laws. So how did we reach a place where one of our most fundamental rights gets treated like a luxury that needs special approval? Personally, The first trace the roots of this problem back to post-Civil War policies. But that's a discussion for another day. If you've got thoughts, I'd love to hear them in the comments. Hawaii's old May issue system basically told law-abiding people that self-defense was a privilege, not a right. If you couldn't prove you were facing some extreme danger, your permit was automatically dead in the water. That's like forcing someone to explain why they need free speech before they're allowed to criticize the government. It sounds like something out of a dystopian novel, but that's exactly how Hawaii's policy worked. Supporters of gun restrictions often argue that more laws mean less crime. But let's be real, criminals aren't showing up at the police station to fill out background checks and pay permit fees. The only people who get punished under these rules are the law-abiding gun owners. They get buried under mountains of paperwork, forced to pay high fees, and most of the time denied anyway. Here's the truth. The Bill of Rights doesn't come with an asterisk. It doesn't say except in states that have different ideas. Once you start treating a right like a permission slip, it ceases to be a right at all. That's exactly why the founders embedded the right to bear arms into the Constitution. They had lived through tyranny under the British Crown and knew exactly how fragile liberty can be. A right that can be denied at a bureaucrat's discretion offers zero real protection. It's just an empty promise, ready to be taken away whenever the government feels like it. If you think Wilson versus Hawaii is just some isolated legal battle with limited impact, think again. If Hawaii's position ends up being validated, it could set a dangerous precedent, giving other states a roadmap to build their own May issue permit systems, all under the excuse of cultural identity or vague public safety concerns. And we're not just talking about one outlier with its own local customs, we're talking about a legal domino effect that could unravel the Bruin decision and every future ruling meant to uphold the Second Amendment. The law isn't just about written statutes, it's about precedent. One flawed ruling in a single state can open the door for similar overreaches elsewhere. That's why gun rights organizations and constitutional experts are following this case so closely. If Christopher Wilson is convicted under a licensing framework that was essentially impossible to comply with, the message to other anti-gun states will be clear. If you can't outlaw firearms outright, just build a permit system so convoluted that no one can make it through. But if Wilson wins, that would send an unmistakable message to every state in the Union. You cannot hide behind cultural slogans or loosely defined safety arguments to sidestep Bruin and ignore the Second Amendment. It would also energize law-abiding Americans to push back against state and local restrictions that clearly cross the constitutional line. The Constitution isn't some buffet where the government can cherry-pick which rights to offer. It's the highest law in the land, binding in all 50 states, from Maine to Hawaii. And if one man's legal battle helps reaffirm that truth, the ripple effect could empower every citizen who believes in their natural right to self-defense. Now maybe you're wondering, what can you do if you're rooting for Wilson and outraged by Hawaii's judicial gymnastics? First, stay informed. Knowledge is your first weapon in this fight. The more you know about cases like this, the better prepared you'll be to challenge anti-gun narratives, whether in conversation, online, or at the ballot box. Watch what your local, state, and federal lawmakers are pushing, because their agendas can either guard your rights or erode them behind closed doors. Second, consider backing the groups fighting these legal battles head-on. Lawsuits aren't cheap, and lobbying for freedom takes real money and real manpower. Whether it's the Firearms Policy Coalition, Gun Owners of America, or a grassroots group in your area, every membership, donation, and volunteer hour helps build the defense line against state overreach. And finally, do not underestimate your own voice. Speak up at public hearings. Write your elected officials. Share accurate, well-sourced information on social media. Public pressure matters especially when it's backed by truth, persistence, and a rock-solid belief in individual liberty. Because let's face it, the Constitution doesn't enforce itself. It needs active, informed citizens who refuse to let any level of government chip away at the freedoms that generations of Americans have fought and died to protect. That's a wrap on this one. The fight over Wilson's case isn't finished yet, but make no mistake, the Bruin ruling has already forced Hawaii to rethink how it handles concealed carry. The aftershocks of that decision are still shaking up the legal landscape in states that once treated the Second Amendment like it was optional. Sure, the wheels of bureaucracy turn slow, and court battles can take years. But history shows us that when enough Americans hold the line, even the most deeply entrenched policies can be torn down. Because this isn't just about Hawaii, it's about reminding every judge, every lawmaker, and every bureaucrat in this country that the Second Amendment is not a favor granted by the state. It's a core American freedom. When the government tries to place itself between you and your right to defend your life and your family, the courts, and more importantly, the people have a duty to push back. A free society only survives when its citizens can both protect themselves and hold authority accountable. And that's exactly what the founders intended when they enshrined the right to keep and bear arms in our Constitution. Thanks for sticking around to the end. If you enjoyed this breakdown, hit that like button. Share this with your fellow Second Amendment supporters, and don't forget to subscribe and ring the bell so you never miss a future update. Your support helps us keep producing content that defends your rights and keeps the truth front and center. Thanks again, and stay vigilant.